a veteran who was kicked in the leg by a horse as a teenager, enlisted, and it was documented, oh, he's got a trick knee and this and that. And they make him run for miles with an 80-pound pack on his back. You get degenerative arthritis in that knee, and the VA goes, no, that's from your horse kick, not from anything that happened to you in service. And so for a veteran who's facing a denial like that, where do you start?
Well, there are a couple of important places to look, but the place to start specifically is the Veterans Service Entrance Exam. And the reason you start there is that there is what's called a presumption, meaning that the law assumes certain facts.
Welcome to the Victory Over VA podcast, a podcast about empowering veterans to overcome denied disability claims. Each week, we deliver critical insights to help you understand the disability process, veterans' benefits, and how to take control of your legal rights. Now here's your host, Tony Francis Jackson.
Welcome to Victory Over VA, your guide to unlocking veterans' disability benefits. If you're a veteran applying for benefits, be sure to subscribe to our podcast for the latest developments in VA disability. I'm Francis Jackson, this is Kristian Terison, and we're veterans disability attorneys at Jackson MacNichol, where we focus on veterans disability. We've helped thousands of veterans to win millions of dollars in benefits. And we've created this podcast as a resource for veterans who are applying for disability benefits. But it's really for anyone who has an interest in veterans' disability issues, whether you're a family member, a community member, or just someone who wants to support our veterans and wants to understand a little more about the disability benefits available to veterans. Today's show is all about preexisting conditions
today.
Okay.
And this one is not one that comes up very often, but when it does, it's often very important. And so can you go over a little bit about what constitutes a pre-existing condition in the veterans disability context?
Sure. So the way the veterans disability system works, you have to show that you have a condition that either was caused or is directly related to your service, or that you had a medical condition that was aggravated or made worse by an element of your service. Often it will be basic training, in fact, but some element of your service. So what has to happen is that you have to show, number one, that there was a pre-existing medical condition, and number two, that something about your service made that condition worse on a permanent basis, and typically it worsened more than it would have but for service. There are some nuances there that we'll talk about, but those are kind of the general outlines.
Yeah, and sadly, in my own practice and experience, the time I see pre-existing conditions referenced the most is when the VA uses them to deny a claim. A veteran who, was kicked in the leg by a horse as a teenager, enlisted, and it was documented, oh, he's got a trick knee and this and that. They make him run for miles with an 80-pound pack on his back. You get, degenerative arthritis in that knee, and the VA goes, no, that's from your horse kick, not from anything that happened to you in service. And so for a veteran who's facing a denial like that, where do you start?
Well, there are a couple of important places to look, but the place to start specifically is the Veterans Service Entrance Exam. And the reason you start there is that there is what's called a presumption, meaning that the law assumes certain facts. And the presumption is that if you entered the service and you had a service entrance physical examination, and the VA did not note that you had a trick knee, even if in fact your condition was from getting kicked in the knee by a horse when you were 15, there is a presumption that your condition was aggravated by service. There's a famous case in the litigation context, Wagner versus Principi, where the Federal Circuit Court of Appeals went through and explained in great detail how these legal pieces go together to get to that result. But the result is very favorable for veterans. If you had a condition that occurred prior to service but was not listed as a disability when you entered the service, then you're going to get this presumption. Now, the place it gets tricky is looking at what was said at the entrance exam. So the law makes this kind of fine distinction between two things. One, there is a record that you had a problem prior to service, versus two, there is a record that you had an ongoing problem when you entered service. So if the VA writes down, or sorry, the medical examiner writes down when you go into the service that you had a history of asthma as a child, that is not a problem. If the VA examiner writes down that you had a history of asthma as a child and you're continuing to have symptoms when you enter the service, that's a problem. There are two different sets of results that stem from that. If the examiner simply writes down that you had a history of some medical condition prior to service, but doesn't say that it's a current disability interfering with your ability to function, then you're still entitled to the presumption of aggravation. However, if the examiner writes down that you have a particular condition that rises to the level of a disability at the time you go into service, then you are going to have to show that the burden is going to be on you. There'll be no presumption. The burden is going to be on you to show that, number one, the condition got worse, number two, that it was as a result of service, and number three, that it worsened more than the condition normally would have worsened with time. So, for example, if you come into the service with high blood pressure and 20 years later you make a complaint and file a claim for high blood pressure, the examiner's notation is going to be critical. If the examiner said, you've got high blood pressure and that's a disability as you come into the service, you're going to have to show that your blood pressure got worse, that part's probably easy, that it was as a result of service, that's a little harder, and number three, that it got worse more than just being 20 years older would have caused it to be. And that can be a very difficult problem.
So I guess the next logical step is, what do veterans who are facing that problem, what kinds of evidence are strongest to establish?
Sure. Well, most of these pre-existing condition cases, as you mentioned, are simply a reason for the VA to deny the claim, and typically without a lot of examination of the underlying facts. Most of the pre-existing condition cases that we see do not have a careful delineation by a person doing the entrance examination that this is a continuing disability, a disability that's present at the time you enter service. And that's critically important. Most of these cases just turn on the fact that VA looks and says, oh, well, you have a record of having asthma as a child, and so these breathing problems that you have now are really pre-existing condition. It didn't get worse in service, goodbye. But most of the time, there is not anything from the examiner delineating that you actually had asthma with active symptoms at the time you entered service. And I keep making that point because there's a great case from the Court of Appeals for Veterans Claims, the McKinney case, in which the court said, look, we understand that the examiner wrote down that Mr. McKinney had some hearing problems at the time he entered service. But they're minor problems that were not a disability. Now he has a disability. That's different, and he's still entitled to the presumption of aggravation. McKinney wins. So it's very important in these cases to pin down exactly what the evidence was at the time of entrance into service, what the examiner wrote, and what the evidence is about the condition prior to service. What happens a lot in these cases is a person will go into the service. They'll be accepted at the entrance exam, no problem, they're doing fine. They'll be put through a rigorous basic training regimen where running a lot, they're doing calisthenics, they're doing various other things that are physically demanding or emotionally demanding, as the case may be, and symptoms will emerge. And the VA will look at the fact that the service then sent them to a medical board, and the medical board will almost inevitably write, existed prior to service, this person can't continue in service because the symptoms are too severe, but this condition existed prior to service and is unrelated, goodbye. And most of the time, there is little or no evidence of any actual symptoms prior to service. There's little or no record of any actual treatment prior to service. The person will simply have told the examiner from the medical board that, oh yeah, I had some problems with this knee years ago. Nothing shows up in the entrance exam, but the folks at the medical board decide that the problem that he's developed during basic training or she's developed during basic training is severe enough that they shouldn't stay in the service, and so they will medically discharge them and say it existed prior to service, and that's that. My favorite example, one of the cases I had early on in my career, we had a young man who was a sophomore in high school, and he was shot in the back in a hunting accident. He was out hunting with friends, shot in the back with a .22 caliber bullet, which is a relatively small bullet. But the bullet lodged in his spine. And so the neurologists who looked at it said, this isn't causing any symptoms now that the immediate wound is healed. Performing surgery where the bullet is lodged right against the spinal cord is very risky, and we advise against it. We think we shouldn't do this surgery. So the young man goes on and is in the track and field, throws the discus, throws the hammer, strong, healthy. His father's been in the service, he goes in the service, and in the course of basic training, the spine, the back area where he was injured, becomes symptomatic. And nobody can say for certain whether the bullet actually moved in relation to the spinal cord or what happened, but it became symptomatic. He started having serious back pain and symptoms. So the folks in the service gave him a choice. They said, look, you can have surgery and we'll remove the bullet. There's some risk, but we'll do that. Or we can give you a medical discharge. You take your pick. And having a few years earlier been through extensive evaluations with multiple neurologists, neurosurgeons about removing the bullet, and having been counseled that was not a good idea, he declined to have the surgery. And so they booted him out. And this is a young man who had been in the ROTC program at his local school, wanted to make the Army a career, and became very depressed at losing the possibility of an Army career. And we argued that, yes, this bullet was a pre-existing condition, but A, it didn't cause any problems that kept him out of the service. They examined him and found he was fine. And B, the depression didn't exist prior to service. And it was the depression that was the problem currently. And it took several years, but we eventually won that case and got him a big award of benefits. And unfortunately, he has never, from the time he left the service up through the point of his award and since, he's been seriously depressed and hasn't been very functional, but now he at least has money to live on.
And I just wanted to add a little aside about when it comes to psychiatric conditions, particularly the names that we give the diagnoses and how those have changed over time, because I've seen cases where somebody will be claiming a DSM-5 psychiatric impairment that's been diagnosed, and then going back to having roots in their military service, but coming in, there was documentary evidence of a nervous episode or something of that nature where it's almost like a pseudo-diagnosis. And what can veterans do, especially older veterans who may have one of these dated diagnoses appear on their entrance exam or in their medical records as a part of enlisting, but now, in the modern era, have a more specific diagnosis and had an exacerbation beyond the normal course.
Sure. Well, usually those can be, I hesitate to use the word resolved, but those can be dealt with primarily by getting a thorough expert medical opinion dealing with it. But, the scenario you mentioned where there's something prior to service, I haven't seen that one as much as what I've seen a lot is in the Vietnam era in particular. I've seen a lot of folks who were discharged for what the service called a personality disorder. And the reason that they put that label on it is that VA treats personality disorder as not only a pre-existing condition, but as a pre-existing condition that cannot be made worse, essentially. So they call it a characterological defect. And so you're not eligible for benefits based on a personality disorder. And lots of times people would be discharged from the military with this personality disorder label with silly things like immature personality. That's certainly not a diagnosis, or at least not a diagnosis that's ever existed in the DSM.
Problems with authority.
Yeah. And I had one case, just very frustrating, sad case, where this young man served 2 tours in Vietnam, been recommended for officer candidate school, and after his second tour, they had him serving as an instructor stateside, and he just blew up a couple of times. And the folks at the service, he was in the Marines, has a personality disorder and booted him out. We had him extensively tested. He did not have a personality disorder. What he had was very severe PTSD. He'd been assigned as an interpreter, working primarily Vietnamese forces and interpreting back to U.S. forces the intelligence that they gained. And in the course of that, he'd seen them do some really horrific things and was really disturbed about that and developed really bad PTSD. But the VA was denying him benefits because the label in his discharge was personality disorder. And so we had to get an evaluation by a psychiatrist, and we ended up getting some supplemental opinions as well after that. But we eventually persuaded the VA that A, there was no personality disorder, and B, that he had PTSD and was entitled to benefits. But going back to your hypothesis about coming in with some unusual diagnosis pre-existing, I just haven't seen a lot of that, but you would handle it the same way. You'd get an expert opinion explaining that either no such diagnosis ever existed, or that under the current regulations, the VA is required to focus on the current DSM-5 diagnoses, and whatever label he had before is not a DSM diagnosis, doesn't correspond to any DSM diagnosis, and can't be used as a basis for rejecting his entitlement to benefits.
In this particular case, we got a really wonderful report from one of the psych experts we work with, who's a diplomate in the traumatic stress, is it society? I can't.
Yes, society.
In any event, detailing sort of the evolution of the diagnosis, what symptoms went into it, how it was known in the DSM-5, and why what appeared to be this pre-existing condition was in fact just a sort of catch-all label that couldn't be construed to constitute a diagnosis. And we ended up prevailing in that one, but it really required a lot of not only psychiatric expertise, but almost psychiatric history as well.
Yeah, I mean, there's been a lot of evolution in psychiatry over the last 50 years. Not just law that has evolved.
Oh, sure.
So it gets interesting.
Come a long way from shell shock.
Yes.
And on that note, that's all the time we have for today. Thank you for joining us for another episode of Victory Over VA. Please be sure to subscribe and join us again next week.
We'll look forward to seeing you then.
Thanks for joining us this week on the Victory Over VA podcast. Make sure to visit our website, veteransbenefits.com/podcast, where you can subscribe to the show in iTunes, Spotify, or via RSS, so you'll never miss a show. While you're at it, if you found value in this show, we'd appreciate a rating on iTunes, or if you'd simply tell a friend about the show, that would help us out too. If you like this show, you might want to check out our free consultation to see how we can help you with your denied claim. Simply go to veteransbenefits.com and fill out the form. You fought for us. Now let us fight for you. And be sure to tune in next week for our next episode.